Good afternoon, everyone. I'm Nidhi Hegde, Executive Director of the American Economic Liberties Project. And I have to say, the last week has felt like a good week to be doing this work, despite the challenges we're seeing more broadly in our politics and economy. So this is a celebratory call. So last week, a federal jury found Live Nation Ticketmaster to be an illegal monopoly. It was a tremendous win for the anti-monopoly movement. Everyone is familiar with the abuse of Ticketmaster. We've all felt it. The site crashes, the hidden fees that double the bill, and the crushing realization that there is no alternative. That is the raw reality of monopoly power, and Ticketmaster has been the ultimate example of what happens when a company answers to no one because they own the entire game. And that's what drove us to launch Breakup Ticketmaster, along with fans, artists, and artist advocates to make the case that the government had both the tools and the obligation to act. Former AAG Jonathan Kanter, who's here today, answered that call. He brought the case. This was an important moment in a long storied fight against the companies, starting with Pearl Jam, to take you back. But then early this winter, just days into the trial, the Trump DOJ pulled back, settling with a sweetheart deal, reportedly under pressure from powerful insiders. It looked like the fix was in. And that's when state attorneys general stepped in and refused to blink. They kept the case alive, and last week they won. A jury of ordinary citizens saw right from wrong. In a moment when so much feels rigged, when accountability feels increasingly out of reach, that matters enormously. So today we will hear from two of those attorney generals, New York Attorney General Tish James and Colorado Attorney General Phil Weiser. And we owe them a tremendous amount of gratitude for seeing this through. It was not easy, but they really stepped up, and it was fantastic that it was also a bipartisan group of attorneys general. Of course, the fight is not over and there's more work to be done. So that's the purpose of this call today, to celebrate this win, but also hear from the people who made it happen and to understand from their perspective what this means for the longer and much harder fight against monopolies like Ticketmaster, especially as a corrupt federal government stops performing its duty. This is one of many fights, and we are doing this call so that we call on you to come join in other fights that are happening. This is not just about Ticketmaster, it's happening across the economy. So with that, I'm going to turn to Morgan Harper, who led this work at Economic Liberties and is the Director of Policy and Advocacy. Morgan.
Great. Thanks, Nidhi. And thank you again, everyone, for joining us. We're really happy to have a discussion today with, as Nidhi mentioned, former Department of Justice Assistant Attorney General for Antitrust Jonathan Kanter, New York Attorney General Letitia James, and Colorado Attorney General Phil Weiser. So we'll just get into it. Jonathan, I'm going to kick it to you first as the man responsible for bringing this case and bringing together this group of AGs. Can you give us a little bit of context as to what led you to do that and just contextualize it in terms of what had come at DOJ before and the types of monopolization cases that were going?
Sure. And it's just an honor to be here with you and with General Weiser and General James, and on behalf of the states who did such a tremendous job. And it actually caused me to reflect on my first week in office. The first set of remarks I ever delivered when I became Assistant Attorney General was before state attorneys general who are gathered here in Washington. And I had the privilege of sitting down with a bipartisan group of state AGs and saying that, in my view, the states were co-equals. Reminding myself that state antitrust enforcement predated federal antitrust enforcement, and that a successful enforcement regime could not stand alone on the shoulders of the federal enforcement agencies, but had to be a true partnership with our states. And from there on, we brought a whole range of groundbreaking cases with our state attorneys general, and we won a whole bunch of groundbreaking cases with our state attorneys general partners, most often in a bipartisan way, which was really extraordinary. It was a 15-year problem, pretty much, by the time I stepped into office with Ticketmaster and Live Nation. It was the one issue that everybody understood, whether it was no matter where I went, no matter who I talked to. When I said I was an antitrust lawyer, when I said that I was an antitrust enforcer, the first thing that came to their minds was Ticketmaster Live Nation. It was the entry point for almost everybody to understand why monopoly power is both problematic, but also why enforcement against abuses of monopoly power and market power are important as well. And the evidence was there. It was not a lengthy investigation because the evidence we turned up was extraordinarily compelling. And we had this incredible opportunity, along with our state partners, to file this historic claim. And I'm so glad we did. One of the most amazing parts of it was when I was at the DOJ, we couldn't find the last example of a major government antitrust case, certainly by the DOJ, going before a jury. And so we filed two cases with jury demands, one in the Eastern District of Virginia, one here in the Southern District of New York against Live Nation Ticketmaster. And we also made sure that we had, and we did the investigation alongside our state partners. And we made sure that when we went to battle in this most important case, that we had a full complement of states on both sides of the aisle along with us. And we did, and we put that jury demand in. And I'm so glad we did. And I'm so proud of the states for having seen this to the end, not blinking when a weak settlement came from my successors at the Department of Justice, and a compelling case. And it is all the more satisfying, not just for enforcers, but for the public, that a jury from the public made the decision unanimously on every count across the board and ran the table. And it is extremely difficult to disagree with the will of the people. And it is extremely difficult to question the wisdom of a jury. And so in this instance, I think it could have been an unhappy ending, but it is an extremely happy ending. And you take this on the heels of the injunction in Nexstar Tegna and elevated activity by the states in the face of reduced activity from the federal enforcers. And you realize not only why we have state enforcement, but why we need to make sure that we invest in that enforcement. But antitrust, the last thing I'll leave you with is we brought these historic cases, and alongside our partners, including General Weiser and General James, we litigated these cases and we're winning. The cases, these big cases that 10, 15 years ago people said couldn't be won, are being won in court. And now they're being won in front of juries. And so hopefully this serves as a mark and a form of motivation that we need more enforcement, because the law and courts and juries will tolerate it.
Great. Thank you, Jonathan. And yes, Attorney General Weiser, I'll turn to you to give some of that state attorney general perspective that Jonathan was referencing. Can you take us back to the decision to both join the case and that bipartisanship that happened, and then also in those moments in the first days of trial when a settlement was being discussed that you all decided to push forward on your own?
Well, I remember in Jonathan's office talking about this case and him saying to me what he just said about his view of the states and wanting to be real partners. And both with Ticketmaster and RealPage, two cases Department of Justice led that get to the abuses that consumers have suffered. And Ticketmaster, we have all suffered because of this enduring monopolist. People get it. RealPage, many people didn't realize they were paying more for their rents because of collusion using algorithms. In both cases, and again, this is the type of leadership that I want from our federal government. We as states were respected. And what was done in both cases was Jonathan accommodated, and I give him credit for pushing the staff on this, damages claims. A lot of times the Department of Justice, because it doesn't have the direct authority as for damages, undervalued states as partners, undervalued states' authority to seek damages. So one of the remedies that's going to be in the Ticketmaster case is getting consumers money from overcharges. That remedy comes from the ability of states to seek such relief. Jonathan embraced that partnership, and I thank him. And Lena Khan, when we worked on a grocery store merger, another case that hits people in the pocketbook, she embraced the states as partner, and both Washington and Colorado brought parallel cases in state court to the federal case. That also is unprecedented. I did 19 town halls in Colorado hearing about this grocery merger, and Lena Khan came to one of them. So the first feeling I have is gratitude for the partnership that was initiated. Secondly, you put me on the where was I? How did I think about it? I was shocked. The judge was shocked. This trial had such incredible evidence. Why wouldn't you put it on? We are unfortunately at a time of heightened corruption, heightened political deals, sweetheart deals for our friends, punishment for our enemies. That's not what the rule of law is. That's the rule of whim. And right now, state attorneys general, we're standing up for consumers and the rule of law. And I'm so proud this case was bipartisan. From the very beginning, Jonathan made it clear that he wanted bipartisan state AG leadership, and we had it. A few states went with the DOJ, but almost the entire coalition stayed together, and we had an incredible leader in Tish James. I want to make this point clear because a lot of times people they take weak settlements because they're afraid to litigate. Well, anyone who knows Tish James knows she's not afraid, and she embodies everything that we need in this moment. She stood strong in this case, leading New York and a multi-state team, and she herself has been standing strong against this administration, trying to intimidate her. Well, anyone who knows Tish knows she can't be intimidated. She fights for what's right. That is something that we did as states, and it's worth noting that the DOJ was shown to be corrupted, afraid, and taking a sweetheart deal that wasn't putting consumers first. By contrast, the state AGs believed in the jury system, fought for what's right, and is holding this company accountable. I'm proud to be a part of it, and really, like I said, appreciate the partnership we've had with Jonathan Kanter and Tish James.
Great. Thank you, Attorney General Weiser. And we're so happy to have Attorney General Tish James here as well. And I will turn it to you. So, we've heard from both Jonathan and AG Weiser about the decision to actually bring this case, the partnership of states, and then that really crucial decision to continue moving the case forward despite the federal settlement. Would love to hear your perspectives on some of the thinking there and why you all decided to keep going.
Well, it's great to see Jonathan. And of course, it's great to see my very good friend, AG Weiser. And thank you for those kind remarks. And it was a great introduction. I appreciate it. So listen, it was a bipartisan effort. It was an effort because we heard from a number of individuals, consumers who were very much concerned about the consolidation of power. And the fact is that Live Nation controlled so much of these live concerts. And we received a significant number of complaints, and we had a duty and a responsibility to join with other attorneys general, as we do often in other cases, in so many cases, but particularly in the antitrust space at a time when the Department of Justice, unfortunately, has turned a blind eye to the consolidation of power, which is affecting affordability, which is impacting the price of tickets, which is impacting the artists, which is impacting the venues. They own Live Nation, and its subsidiary owns significant numbers of these venues. And it's really critically important that we use our powers, again, bipartisan group of attorneys general, use our power, again, to hold them liable. And what we are anticipating as we move forward with respect to remedies is to break it up. And we've not had a case of this magnitude since Ma Bell. And we are prepared to use our positions of power, to use our state laws, and to use the federal law at a time when the federal government, unfortunately, has turned a blind eye and has entered into an agreement which we would argue is rather weak and does not serve the interests of the constituents that we serve each and every day.
Great. And actually, on the settlement piece, and maybe I'll go back actually to AG Weiser real fast for this. That's a question we've gotten is how will this all be resolved? This seems like a complicated situation for the judge. We have the Tuniak review and the settlement, and then also this separate verdict and the state's case. How do you anticipate that will be managed? Or how would you like to see it managed, too, if you can say?
The norm, and we went through this in Google, another good partnership with the federal government, is there'll be a separate remedy phase. And Attorney General James said it very well. The right remedy here, the remedy that we want to see, is a breakup. And let me explain this because not everyone is in the weeds. Ticketmaster Live Nation has 3 separate monopolies. Yes, ticketing is the one that we often are experiencing when we're dealing with the inflated fees. But they also have this monopoly control, this dominant position of venues. And they control all this concert promotion. And what the evidence at trial showed is by controlling those 3 separate levels, they made it really hard for rival ticketing systems to get a foothold in the marketplace. In AG James' backyard, the Barclays Center, they wanted to use a rival ticketing system to get consumers better deals. And what happened? They were punished by diverting concerts away from them. That type of predatory conduct is what this company was able to do because they controlled three levels. They divest the Ticketmaster level. You then open the market to competition. And that's what a effective remedy requires. And what I want to underscore here is we're not dealing with a company on a blank slate. We're dealing with a monopolist who violated a consent decree. They were under a consent decree and they broke the law. They violated the decree. And what the evidence at trial showed is how brazen it all was. There was evidence at trial of the executives of the company making fun of the customers, saying, look how much money we're charging them. These stupid fans are paying this inflated fee. That type of contempt for customers can only happen when you have an enduring monopoly and you're not worried about losing customers. That's why we need serious remedies.
Jonathan, anything you would... Oh, sorry, please.
Can I just also say that not only did they own Barclays, but they also own Madison Square Garden, and also Radio City Music Hall. And some people have said that antitrust cases are, complicated, but the jurors got a clear sense of what was happening here, particularly when those hot emails came out in Texas that came out, which basically said that we were robbing them blind, baby, and that these people are so stupid. And it almost feels bad taking advantage of them. Is what the jury heard. And that is what secured this verdict going forward. And so it wasn't really complicated when you've got texts and emails basically describing you as stupid. The team did a great job. And all of the attorneys general obviously should be proud of all of the work. But now we've got to prepare as we seek remedies. And the remedies, again, is to break up these two companies to get not only behavioral remedies, but also some institutional remedies as well.
Great. And that's where we're going to go next to dig in a little bit more detail on the remedies that you all would expect. But before we do, I just want to go back to Jonathan to ask, other evidence that you found interesting at trial, and then also coming back to your idea, because we've heard from all of you about the importance of pursuing a jury trial here, how that impacts the durability of the verdict and some of the procedural elements that might follow here.
Yeah. So first of all, just on the remedies point, let me say that when we filed the case, we were very clear that the remedy, the only acceptable remedy, would to be break up Live Nation Ticketmaster. And it has become more apparent for the reasons General Weiser said, for the reasons General James said, that is the only remedy, because the evidence at trial was shocking. It was jaw-dropping. And the jury did not waver. They did not find liability on some claims and not on others. It was a cross-the-board victory for the state attorneys general against the monopoly of Live Nation Ticketmaster. The only acceptable remedy here is a breakup. This is a repeat offender. They have had consent decrees before. They violated those consent decrees. They said that those consent decrees, those behavioral remedies, would somehow protect competition. It did not, right? And they violated them with impunity. And they continue to violate the antitrust laws with impunity. When you have a situation like that, and we have a situation where the problem is itself structural, they have a conflict of interest. They represent the promoters. They represent their promoters. They represent the artists. They represent the ticketing. They represent the arenas, and they own the arenas. The only way to address this problem is to eliminate the conflict of interest. The evidence is there to support it, both in terms of the evidence at trial for liability and the evidence of their past compliance with consent decrees. So this is the only right outcome. In terms of I wasn't surprised by anything I heard at trial. We knew that when the jury heard what we heard or what we saw in the evidence when we investigated, that this would be a slam dunk, and it was. But what really impressed me was how in an antitrust case, it didn't need to get overly technocratic. How the litigation team did a stellar, incredible job of giving the jury the information it needed to determine liability. And yes, it had testimony from experts and it had technical information, but it had the facts. It had the intent. It had the company executives talking to each other when nobody was looking and what they were saying come to light. And that just made it so compelling. And I was not surprised by the outcome. And I still believe, as I did the day we filed the case, that a breakup is the only proper remedy here.
But as we all know, and this is another question we've been getting, so I'm just channeling a lot of the side conversations we've been hearing since the verdict. Now it shifts to a judge for that remedies decision. And AG Weiser, AG James, y'all will have to again make your case for these remedies. So how should we be thinking about that? I mean, this is no longer going to be a group of regular Americans that are able to understand, and cut through the issue. This is now going to be potentially what folks perceive as a technocratic judge. Could you share some of your views there? I'll start with AG Weiser and then go to AG James.
The judge heard the evidence too. The judge is on notice of what Jonathan just said, which is we're dealing with a company that violated a consent decree. And I think AG James' reference to Ma Bell and the AT&T consent decree is the right frame of mind. AT&T, people remember, had a history of antitrust litigation against it, including a prior Department of Justice consent decree. That's true with Ticketmaster. This has been an enduring monopoly who's violated a consent decree. And so I don't think anyone can look at this company and say, oh, they made a mistake. Let's give them a chance to follow the law. We're not dealing with a situation like that. We're dealing with an enduring monopolist who, as AG James explained, showed contempt for customers they called stupid for paying inflated fees. This company needs serious medicine. That includes, and AG James said as well, the structural relief, and Jonathan put it well, there's an inherent conflict of interest when you control all three levels. But structural relief won't be enough. We're going to need behavioral remedies as well, making clear that the types of practices they did cannot continue. We have to make sure we get this right and restore competition to the market. And I believe the judge will understand that. And I don't think this company is going to get away with it. They've obviously been squirrely, getting a consent decree that they then violated, getting the Department of Justice a sweetheart deal that would have allowed the monopoly to endure. But now they're up against this bipartisan coalition led by, as I said, one tough fighter, AG James. I think this company is going to get the medicine that consumers need it to take so that consumers can get the benefit of competition, stop paying these inflated fees, give artists more freedom, and help all of us with a robust competitive market.
The verdict sends a clear message, one that when state attorneys general come together, we can get real results for consumers. And two, that when corporations become too big, that consumers suffer the consequences. And that really is the message. And so we will go forward with this second phase of this trial. We'll present evidence to the judge. And as a result of that, we will stop this monopoly. But most importantly, we will get damages. And that is really critically important. And damages for consumers, which is so critically important. I urge everyone, again, to focus on the second phase. And again, it's not as complicated as people would like to believe. It really focuses on the fact that this corporation thought that they were so smart, that they had committed, they were repeat offenders, they were recidivists, and obviously they got caught. They need to be stopped. We need to break them up. We need to stop this monopoly. And what we need to do is make sure that consumers understand that state attorneys general are here to address one issue that they care about, and it's the issue of affordability when they go to see their favorite artists at a certain venue.
Can I just add one thing here? I think this is really important. We are entering the heyday of state antitrust enforcement. Companies should be on notice. It is not enough to cut a sweetheart deal at the White House or at the federal administration. The states are the line of defense, and they are stepping up big time in so many different ways. And so companies are on notice, whether it's a merger or whether it's anti-competitive conduct. You're going to have to face the music because you have courageous state attorneys general across the political continuum who are going to say, not on our watch. And they've proven that now multiple times in just the last few weeks. And we are beginning what is likely to be a very successful, a very long, and a much needed and celebrated run of state antitrust enforcement.
One more thing on that point.
Please,
I put in the chat a speech I gave to the American Bar Association antitrust annual meeting that makes the point Jonathan just said, talking about it. It's very important to know. And also, when Jonathan was the head of the antitrust division, he filed in the case that we brought against the supermarket merger here in Colorado and underscored the principle that states have this authority under the antitrust laws, even where the federal government takes a dive, doesn't do a serious settlement, states have the ability to go forward, as we've done in Live Nation, as we're doing in other cases, Nexstar, Tegna. This is an important principle, and I am grateful that our republic has federalism that gives states sovereign power to enforce the law and protect consumers, even when the federal government won't.
Yeah, I think thank you, my good friend AG Weiser. And he gave me a lot of credit. But the reality of the situation is I learned so much about antitrust law from him. He wrote the book, The Black Letter Law. And so I really want to thank him. I also want to say Congress should exercise its oversight authority with respect to these mergers. And it's unfortunate that they too have been absent. And it's really critically important that they exert their influence and they use their oversight ability and their authority to examine these mergers going forward, because they basically hurt consumers. And so it's really critically important that individuals understand that.
Let me add one more point if I can, which is when Congress is able to do real oversight, it needs to look at these corrupt dealings. Why are some companies getting favors while other companies are getting hard scrutiny? I believe in fairness, and the idea, I mentioned this before, of the rule of law means no matter who you are, the law applies to you fairly. And if you're a favored company, Nexstar trying to take over Tegna, or Live Nation Ticketmaster, you get a sweetheart deal where other companies or individuals get the book thrown at them. That's wrong. That's un-American. Congress needs to look into that too.
In addition, for Congress, what we're seeing is a parade of lobbyists going up to Capitol Hill saying they want federal preemption of state enforcement. We're seeing it in areas like AI and numerous other sports and other areas. Why? Because the states keep winning, because the states are exercising their rights, because of the principles of federalism. And I think what's really important that everyone listening to this put pressure on their members of Congress not to give in, not to take the ability away from the states to enforce their own laws and to protect consumers and to protect competition. But we will continue to see that parade of lobbyists going up to the Hill. And Congress has to stand firm and say, no, we are not going to preempt state antitrust enforcement.
Cryptocurrency, on AI, on gambling, on mergers, they basically want to preempt our authority. And what they really need to do is respect the dual sovereignty and the power and the authority of state attorneys general, period.
I love that. I have one final question. Thank you so much to all of you for joining us. I could talk to you all for the whole day, but I know you have busy schedules. To put a finer point on, because I think you all have touched on this idea of almost restoring faith in the government, that it can deliver, that we can see outcomes that serve us as the public. Wave a magic wand, even in broad strokes, what do you hope the public sees on the other side? We know we have another phase here, the remedies. It'll be a few months, maybe longer. People are actually going to get money in their pockets. What does this market look like? How would you see that or describe that transformation to close us out?
I'm happy to go first.
Yeah.
Okay.
No, you want to go first, Tish?
Go ahead.
What I would say is I want consumers to know they're getting more choice. Consumers deserve alternatives, having the ability to get different ticketing systems that provide higher quality. We talked about the crashing of the websites that provides lower fees. Consumers deserve choice. When you've only got one option, that's a monopoly. That tends to give people abuses. Artists deserve choice, what ticketing systems they want to go with, and the pressures that are now being faced. Jonathan called it the conflict of interest. If you want to go to this arena, you have to use this ticketing system. Or if you are an arena and you want to use a different ticketing system, then you don't get artists. That's all got to stop. We got to open up this market to competition at all the levels so that fans, artists, arenas, all of us are better off. The only person who's going to be worse off because of this case is Live Nation Ticketmaster. Their monopoly and their monopoly profits are going to end.
I want to put an end to the unprecedented control, the unfairness, the abuse, and the anti-competitive practices. I want people to go to see Taylor Swift. I want them to get a good ticket price. I want them to go to their favorite venue. And I don't want one company to have control over the marketing of Taylor Swift. Right after Taylor Swift, we got tons of complaints. And so we want to avoid that going forward. And we want all fans to make sure that they can see any artist of their choice and not have to be robbed, period.
And I would add that courageous leaders are necessary for good outcomes, for great outcomes. Attorney General Weiser is a courageous leader. Attorney General James is a courageous leader. The other states that stayed in this fight and won a trial are courageous leaders. That is what we need to demand of our people. We need to demand that of our government. And we need to demand that they stay courageous and continue fighting these fights, because they will and they do yield good outcomes. If you care about concentration of power, if you believe that concentration of corporate power is antithetical to our democracy, it's antithetical to our way of life, it's antithetical to an economy that provides opportunities for everybody, then we need to say thank you to these courageous leaders, and we need to encourage them to continue doing more, not less.
Period. All right. Well, thank you so much. I have nothing left to add to that. Really appreciate your time. Thank you so much for this conversation. We look forward to continuing to follow the case along. Following along with the case, I should say. We do have one last speaker, another member of the Breakup Ticketmaster Coalition, joining us to provide closing remarks, Kevin Erickson, Executive Director of the Future of Music Coalition. Kevin, close us out.
And I just want to say thank you to our guests here for their heroic and courageous work, and I'm so proud to have been fighting alongside you. Grateful as well to the Economic Liberties for your leadership through the coalition, and also for your intellectual leadership. There were a lot of people who had a lot of opinions about how this case should be handled, and some of them were very bad. And if the plaintiffs had followed that advice, we might have well be in a different place. I work to elevate the perspectives of musicians and us and the other artist groups in this fight. These are not clients we represent. These are our friends. These are our communities. These are the bands crashing on our couches while they're on tour. We've been watching our communities and our fans getting crushed by this monopoly for years. And adding insult to injury, in discussion of these industry issues in DC, we have years of panels and policy briefings on this topic, which did not include voices from artists or artist organizations or even any independent music venues. Lena and Doha said this in a New York Times op-ed yesterday. Too often the information guiding government is overwhelmingly skewed toward those well steeped in the power corridors of Washington. And so it represents an important course correction for antitrust that through the complaint that Jonathan and his team brought and through the case that the plaintiffs argued, they also chose to listen to the voices and the analysis of impacted stakeholders. I was able to attend the closing arguments, and I can't tell you how gratifying it was to hear the lead attorney, Jeffrey Kessler, make the case, our part of the case, in front of the jury, that this monopoly was limiting artists' choices of where they could play, engaging in controlling and coercive behavior. And it was all the more powerful with the weight of all of the new evidence that emerged at trial about Live Nation's duplicity in claiming to be on artists' side while complaining about the fan-friendly practices that artists wanted, claiming to be doing something about bots while actually rapidly working to move into the secondary market so they could charge more fees. And in the face of all of this, there's a lot of fear to overcome. But when you see people in a position of power giving voice to your long-held frustrations, when you see people standing up to the bullies, you start to get a little more courageous yourself. We have seen our friends at the independent venues go from privately critical of Live Nation to emerging as one of the boldest and most effective anti-monopoly voices. And so I think that's one of the important lessons of this trial. When antitrust enforcers and other decision makers and advocates listen to the voices of workers and impacted small businesses, perspectives that have historically been left out, that is the way to understand what's actually happening on the ground, to get the analysis right. And in turn, that's the path to winning. It's worth thinking about in federal and state fights and rulemakings and even legislation, but it applies to remedies as well. This is a pivotal moment and the fight is not over. We cannot replicate the mistakes of the past with more weak consent decrees that don't work, that for artists create untenable monitoring responsibilities. We have the least amount of resources. We don't have the ability to monitor for more misbehavior, nor could we rely on interoperability measures, which without a breakup could just translate to ongoing dependence. We need that breakup, and it's not just about separating the ticketing business from everything else. It's also looking at the relationship between tour promotion and venue ownership. It's that core source of Live Nation's coercive leverage in ticketing amphitheaters. It's the tour and limiting their power over using those tours for anti-competitive conduct is something that the remedies do have to meaningfully address to be able to truly address the illegal monopoly. Otherwise, we're going to continue to feel the impacts. We're going to continue to be pressured into accepting these terrible terms and extractive practices that Senator Blumenthal's important new report details. So don't listen to Live Nation's spin and PR campaign, which is in overdrive right now in the media. A splintering of Live Nation is probable and it is necessary. It is only a structural separation of these linked lines of business that's capable of getting at the root of the problem. That is how we make this not just a milestone victory against this one company, but a template for how we can build a broad movement together. Thanks, and I'll throw it back to you, Morgan.
Great. Thank you, Kevin, again, to all of our enforcers that joined us. If you're like us and you almost shed a tear when this verdict was delivered, then we have a home for you. It's called the American Economic Liberties Project and the Breakup Ticketmaster Coalition, and we would love to be in touch. Like you've heard today, we're just getting started. So please reach out directly. We will continue to keep everybody updated on the trial. And again, thank you to the set of enforcers, all of the advocates, everyone in this industry that has fought for years to get to this point. And we'll make sure that we get this to the finish line with a real breakup and real structural solutions. Thank you for joining us.